Okay. Welcome again to another lecture on the basic Philippine law and jurisprudence channel. Our topic for today is parental authority. This is again a continuation of the series of lectures on persons and family relations law. Okay. Our topic is parental authority. Okay, as you would know, parental authority is an offshoot of filiation. Okay, so what is parental authority? Article 209 defines for us what parental authority is all about. Okay, what are its inclusions? Okay, parental authority and responsibility shall include caring for and rearing of children, for civic consciousness and efficiency, and the development of their moral, mental, and physical character and well-being. Okay? It is something which is personal. So it cannot be transferred. It cannot be renounced except in cases authorized by law. Okay? The law provides for specific grounds for suspension or termination of parental authority. Okay? So who exercises parental authority? There are different kinds of parental authority. Okay? With respect to the parental authority of the natural parents, the father and the mother, I call it primary parental authority. When they are already gone, the parents are gone, both of them. Okay, the grandparents or the oldest brother or sister, okay, may exercise substitute parental authority. There is also such a thing as special parental authority. This is exercised by the schools or the learning institutions which the child may attend. Okay? So while they are at school, they are under the special parental authority of the school. We also have the so-called supplemental parental authority, as we can see later in jurisprudence, which is the state. The state as parens patriae can exercise its supplemental authority over children by imposing certain restrictions to promote their welfare and well-being. Okay. So let us go back to primary parental authority exercised by the parents over their children. So Article 211 states that the father and the mother shall jointly exercise parental authority over their common children. Now, what if there is a disagreement in the decision of the parents? It is the father's decision who shall prevail, subject to question or challenge by the mother, okay, and in a proper proceeding in court. Okay, children, there is also a corresponding obligation on the part of children to always observe respect and reverence towards their parents and are obliged to obey them as long as the children are under their parental authority. Okay. Now, Article 212 tells us that in case of absence or death of either parent, the parent present shall continue exercising parental authority. Now, what if the present parent has remarried? Okay, the remarriage of the surviving parent shall not affect the parental authority over the children unless the court appoints another person to be the guardian of the person or property of the children. What if the parents have already separated? Okay, the parental authority shall be exercised by the parent designated by the court. The court shall take into account the choice of the child over 7 years of age unless the parent chosen is unfit. However, if the child is under 7, okay, he shall not be separated from the mother unless there are compelling reasons to order otherwise. Okay. How about if both parents have already died, or both of them are unsuitable, or both of them are absent? Then substitute parental authority comes in. Okay. Who shall exercise it? The surviving grandparent. So either the paternal or the maternal grandparent. If both are present and are willing to exercise substitute parental authority, then the court will decide. Okay. Now, there is an order of preference with respect to persons who can exercise substitute parental authority as follows. Okay, the surviving grandparent, the oldest brother or sister over 21 unless unfit or disqualified, or the child's actual custodian over 21 unless unfit or disqualified. Whenever it is necessary, the appointment of a judicial guardian over the property of the child, the same preference shall be observed. Okay, so you cannot appoint the older brother or sister, the oldest brother or sister. There is a surviving grandparent. Okay, how about in case of foundlings or abandoned, neglected, abused children? Who shall exercise parental authority over them? Heads of children's homes, orphanages, and other similar institutions duly accredited by the proper government agents. Okay. Article 218 provides for special parental authority exercised by the school, administrators and teachers, or the individual entity or institution engaged in child care. Okay? Unless while under their supervision, instruction, or custody. So, uh, these institutions, the learning institutions, the school, shall have parental authority special at that over the child while the child is under their custody. Okay. Now, what is the obligation or responsibility of those exercising parental authority over children? Okay, under Article 219, okay, they shall be principally and solidarily liable for damages caused by the acts or omissions of the minor, the parents, judicial guardians, or the persons exercising substitute parental authority shall be subsidiarily liable. Okay, their respective liability shall not apply if they have exercised the proper diligence required under particular circumstances. Okay. Now, what are the obligations? So aside from being subsidiarily liable for the damages caused by the minor, what are the other rights and duties of those exercising parental authority over minors? They are as follows, listed under Article 220 of the Family Code. Okay, to keep the minors in their company, to support, educate, and instruct them by right precept and good example, to provide for their upbringing. Okay, to give them love and affection, advice and counsel, companionship and understanding. Number three, to provide them with moral, spiritual guidance, inculcate in them honesty, integrity, self-discipline, self-reliance, industry and thrift, stimulate their interest in civic affairs, and inspire in them compliance with the duties of citizenship. Enhance, protect, preserve, and maintain their physical and mental health, furnish them with good and wholesome educational materials, supervise their activities, recreation and association with others, protect them from bad company, prevent them from acquiring habits detrimental to their health, studies, and morals, to represent them in all matters affecting their interests, demand from them respect and obedience, and impose discipline on them. Okay? Parents and other persons exercising parental authority shall be civilly liable for injuries and damages caused by the acts and omissions of their unemancipated children living under their company and under their parental authority. Okay, what is the effect of parental authority on property? What if the property of the child is 50,000 pesos? Is it still covered by parental authority of the parents? Article 225 states that the father and the mother shall jointly exercise legal guardianship over the property of their unemancipated common child without the necessity of court appointment. So if you are the parent, you need not go to court to be appointed as a guardian. So by operation of law, you become the automatic guardian of your children. But if the property of your child is 50,000 pesos or more, you have to go to court and file a summary proceeding for the approval of a bond. Okay, not less than 10% of the value of the property of the minor. The same is true if you want to sell the property of the minor. You have to seek special permission from the court through a summary proceeding for the purpose of selling the property of the minor. When the market value of the property or the annual income of the child exceeds 50,000, the parent shall be required to furnish a bond in an amount the court may determine, but not less than 10% of the value of the property or annual income to guarantee the performance of obligations for general guardians. A verified petition for approval of the bond shall be filed in court. The property of the emancipated child earned or acquired by work or industry shall belong to the child in ownership and shall be devoted exclusively to the child's support and education. So the right of the parents over the fruits and income of the child's property shall be limited primarily to the child's support, secondarily to the collective needs of the family. We now come to the grounds for suspension or termination of parental authority. Remember, parental authority is something personal. You cannot renounce it at will. You cannot waive it. You cannot terminate it or suspend it at will. Okay, the grounds for suspension or termination of parental authority are provided by law, and they are as follows. Article 228 states for the termination, the grounds for termination of parental authority: death of the parents, death of the child, emancipation of the child. So when the child turns 18, okay, automatically parental authority terminates. Okay? When either the parent or the child dies, automatically parental authority terminates. Okay. Parental authority also terminates under Article 229 upon adoption of the child because parental authority now is transferred to the adopter. Upon appointment of a general guardian, the same is true. Once a general guardian is appointed, okay, parental authority is also transferred to the general guardian. Upon judicial declaration of abandonment of the child, okay, in which case parental authority is transferred to the child care institution. Final judgment of a court divesting the party concerned of parental authority, or judicial declaration of absence or incapacity of the person exercising parental authority. Okay. Parental authority is suspended upon the conviction of the parent or the person exercising the same of a crime which carries with it the penalty of civil interdiction. Okay. Article 231, on the other hand, provides for the suspension of parental authority. Okay, as follows. Okay, treats the child with excessive harshness or cruelty, gives the child corrupting orders, counsel, or example, compels the child to beg, subjects the child or allows him to be subjected to acts of lasciviousness. Okay, if the person exercising parental authority has subjected the child or allowed him to be subjected to sexual abuse, such person shall be permanently deprived by the court of such authority. So it is not a ground not only for suspension but of termination of parental authority. If you have subjected a child to sexual abuse or you have allowed him to be subjected to sexual abuse. Okay? The person exercising substitute parental authority shall have the same authority over the person of the child as his parents. Okay? Now, with respect to special authority given to school administrators, okay, in they are prohibited from inflicting corporal punishment against the child. Okay. The purpose of parental authority is to ensure the sound physical development of the child, the nourishment of their affective and sensitive faculties. Okay. We now go to the cases. The first case is the very interesting one. Okay, we have the case of Versoza versus people. Okay, this case involves a special child, a child with cognitive disability. Okay, he was adopted by the Versoza spouses. Now, because his mental age is quite delayed, okay, than his physical age. Okay, being the legal guardians, Versosa being the legal guardians of the child, wanted him to undergo bilateral vasectomy because, in their opinion, it is to the best interest of the child for him to undergo bilateral vasectomy because he could not, according to them, have a family of his own, considering his disability. Okay, now the sister uh, the sister, okay, the religious sister who was in charge of the child at the time when he was still in the orphanage, challenge or question the decision of the guardian for the child Larry to undertake vasectomy or to undergo vasectomy. According to her, it is a violation of Larry's rights. Okay, the decision on reproductive rights is something which is personal to the child and is not embraced within the parental authority of the guardian. Okay. The reasoning of the guardians is that Larry is dependent on his family for his needs. At his capacity, he may never understand the nature, the risks, benefits, consequences of vasectomy that his family wants for protection. Thus, the responsibility of decision making may be given to the parent or the guardian. Now, Sister Versosa filed a case against the guardians as well as the doctors for violation of Republic Act 7610. Because according to Sister Versosa, the guardians of Larry abused their parental authority. So they wanted to strip them of parental authority because they violated the rights of the special child. So the issue is whether the bilateral vasectomy performed on Larry constitutes child abuse under RA 7610. According to the Supreme Court, the exercise of parental authority should be understood more as a sum of duties to be exercised in favor of the child's best interest. It is a mass of rights and obligations which the law grants to parents for the purpose of their children's physical preservation and development, as well as the cultivation of their intellect and the education of their heart and senses. In child abuse cases, the parents or the guardians may be the abusers themselves. Those entrusted with the care and protection of the child could very well be complicit in the abuse, if not its perpetrators. Okay? Under no circumstances must child abuse be allowed to hide behind a shroud of secrecy, even more so if it is committed under the guise of parental authority. Okay? The next case is Masbate versus Relucio. Okay, we have here a child, Queenie, who was born to Renaline and Ricky. They have been living together without the benefit of marriage or under a common law relationship. However, their relationship ended. Renaline went to Manila and left Queenie to her father, Ricky. Now, however, the parents of Renaline took Queenie, okay, from Ricky. When Ricky was taking her back, Renaline's parents refused. And instead, they showed a special power of attorney executed by Renaline, granting them full authority over the custody of Queenie. Of course, uh, Ricky questioned it. Okay, now the issue is whether or not the Court of Appeals correctly remanded the case to the court below for the determination of who should exercise custody over Queen. Okay, as a general rule, the father and the mother shall jointly exercise parental authority over the persons of their common children. Illegitimate children shall be under the parental authority of their mother. Okay, mothers are entitled to the sole parental authority of their illegitimate children, notwithstanding the father's recognition of the child. Mothers are entitled to keep their illegitimate children in their company, and the court will not deprive them of custody absent any other compelling reason. Okay, the following instances may constitute compelling reason to wrest away custody of a child under 7: neglect, abandonment, unemployment, immorality, habitual drunkenness, drug addiction, maltreatment of the child, insanity, or affliction with a communicable disease. However, the CA erroneously applied Section 6 of Rule 69. This provision contemplates a situation in which the parents of the minor are married to each other but are separated either by virtue of a decree of legal separation or because of separation de facto. In this case, it is established that the petitioner and the respondent were never married. So the court cannot adopt a rigid view without running afoul to the overarching consideration in custody cases, which is the best interest of the child. So the best interest of the minor refers to the totality of the circumstances which are most congenial to the survival, protection, and feelings of security of the minor, encouraging her physical, psychological, and emotional development. Queenie's best interest demands that a proper trial be conducted to determine if she had indeed been neglected and abandoned by her mother, rendering the latter unfit to exercise parental authority. So, in this case, even if the mother is entitled to the sole custody of the illegitimate child, still the courts deemed it proper to consider uh, evidence which may be introduced to establish that the mother is unfit to have custody of the child because of neglect or abandonment, which must be established in court. Okay, Spark versus Quezon City. This is regarding the validity of curfew or ordinances, okay, imposed on minors. This was questioned by the minors in this case because according to them, the state is bereft of any authority to impose the said requirement, and that it is the under the parental authority of their respective parents to determine the time under which they are required to be home. Okay. According to them, the curfew ordinances are unconstitutional because they deprive parents of their natural and primary right in the rearing of youth without substantive due process. They assert that this right includes the right to determine whether minors will be required to go home at a certain time or will be allowed to stay outdoors. Okay. Now, is the Supreme Court said that the curfew ordinances are valid and constitutional. Okay, in doing so, the Supreme Court invoked the parents patriae doctrine for the responsibility of the state to take care of the youth. Okay, while parents have the primary role in child rearing, it should be stressed that when actions concerning the child have relation to the public welfare or the well-being of the child, the state may act to promote this legitimate interest. When minors are involved, the state acts as parents patriae. To it is cast the duty of protecting the rights of persons who, because of age or incapacity, are in an unfavorable situation. This parents' patriae is inherent in the supreme power of every state. The state has the inherent right and duty to aid parents in the moral development of their children and thus assumes a supporting role for parents to fulfill their parental obligations. That is why I called it supplemental parental authority. So they can do so under parents' patriae to support parents in the rearing of the minors. The curfew ordinances are examples of legal restrictions designed to aid the parents in their role of promoting their children's well-being. Minors, because of their peculiar vulnerability and lack of experience, are not only more exposed to potential physical harm by criminal elements that operate during the night. Their moral well-being is likewise imperiled as minor children are prone to making detrimental decisions during this time. Okay? We have the case of Caravan, Travel and Tours versus Abejar. This is regarding the exercise of substitute parental authority of the actual custodian of the minor. So in this case, Jess Marian was walking and then he was hit by a van. Okay, now the registered owner of the van was Caravan. Now the trial court rendered judgment finding the driver as well as Caravan jointly and solidarily liable for damages. Now, they were questioning the right of Abejar to the said damages. Why? Because according to them, he does not exercise legal or substitute parental authority over Jess Marian. Only the victim herself or her heirs can enforce that action. Okay. But according to the court ruled that having exercised substitute parental authority, respondent suffered actual damages, thus a real party to the case. Respondent's capacity to file a complaint stems from her having exercised substitute parental authority. Why? Because both of the minor's parents are already deceased. The paternal grandparents are also deceased. Respondent took custody of Reyes when she was a child, assumed the role of her parents, and thus exercised substitute parental authority. Okay. So in this case, she is the actual custodian of the child. Okay. First, respondent suffered actual personal loss with the same anguish that a natural parent would have felt upon the loss of one's child. Okay, so in as much as persons exercising substitute parental authority have the full range of competencies of a child's actual parents, nothing prevents persons exercising substitute parental authority from similarly possessing the right to be indemnified for their ward's death. Okay? We have the case of Bartolome versus SSS. So in this case, John was employed as electrician. However, there was an accident that occurred while he was on board the vessel, which resulted in his death. Okay, at the time of his death, John was childless. Okay, he remained unmarried. Now, the biological mother of John was claiming death benefits from the SSS. However, the SSS denied the claim because she's no longer considered as the parent of John because John was legally adopted by Cornelio. However, his adoptive parent, Cornelio, was no longer alive. So can the biological mother, okay, claim the death benefits despite John's adoption? Okay. Uh, Based on Cornelius' death certificate, it appears that John's adoptive father died less than 3 years since the decree of adoption attained finality. So the Supreme Court uh, constructed liberally the term parents in the case of dependent parents. Okay, dependent parents should include all parents, whether legitimate or illegitimate, whether by nature or by adoption. When the law does not distinguish, one should not distinguish. Dependent parents are parents, whether legitimate or illegitimate, biological or by adoption, who are in need of support or assistance. Okay, so the Congress did not limit the phrase-dependent parents to solely legitimate parents. When Cornelio adopted John, who was then 2 years old, petitioner's parental authority over John was severed. However, uh, aside from Cornelius' death, when the adoptive parent died less than 3 years after the adoption, John was still a minor at about 4 years old. John's minority at the time of his adopter's death is a significant factor. Parental authority should be deemed to have reverted in favor of the biological parent. Okay, so the biological parents retain their right of succession to the estate of their child who was the subject of adoption. Okay, we now move to the case of Tonog versus Court of Appeals. Dinah gave birth to Guardian Faith, her illegitimate daughter, with Edgar. Now, petitioner left for the U.S., where she found work as a nurse. Guardian Faith was left in the care of her father. Private respondent filed a petition for guardianship over Guardian Faith, which was granted. Petitioner contends that she is entitled to the custody of the minor as a matter of law. Parental authority and responsibility are inalienable and may not be transferred or renounced except in cases authorized by law. The right attached to parental authority being purely personal, the law allows a waiver of parental authority only in cases of adoption, guardianship, and surrender to a children's home or an orphan institution. When a parent entrusts the custody of the minor to another, such as a friend or a godfather, even in a document, what is given merely is temporary custody. It does not constitute a renunciation of parental authority. Even if a definite renunciation is manifest, the law still disallows the same. The general rule is recommended in order to avoid many a tragedy where a mother has seen her baby turn away from her. So in this case, we are being asked to rule on the temporary custody of the minor since it appears that proceedings for guardianship could have not been terminated. Bearing in mind that the welfare of the minor is the controlling factor, we find that the appellate court did not err in allowing her father to retain parental custody over her. The child should not be wrenched from her familiar surroundings and thrust into a strange environment away from people and places to which he had formed an attachment. Our pronouncement should not be interpreted to imply a preference towards the father relative to the final custody of the minor, nor should it be taken to mean as a statement against petitioner's fitness to a final custody of the minor. Shall only be understood that for the present and until finally adjudged, temporary custody of the subject minor should remain with her father. So taking into consideration always the best interest of the child, because the child is already familiar with the family of her father. Okay? St. Mary's Academy. Okay, this is a case involving special parental authority. Okay. St. Mary's Academy conducted an official uh, an official activity outside of school. However, in that activity, Sherwin, along with other high school students, while riding a Mitsubishi Jeep, uh, figured into an accident. Okay? The latter drove the Jeep in a reckless manner, and as a result, it turned out turtle. So Sherwin died as a result of that accident. So in the case of St. Mary's, the Supreme Court stated that the following shall have special parental authority over the minor child while under their supervision, instruction, or custody: the school, its administrators and teachers, the individual entity or institution engaged in child care. This special parental authority applies to all authorized activities, whether inside or outside the premises of the school, entity, or institution. Such authority applies to field trips, excursions, and other affairs of the pupils and students outside the school premises. So if the person under custody is a minor, the one exercising special parental authority are principally and solidarily liable for damages caused by the acts or omissions of the minor while under their supervision. For petitioner to be liable, however, there must be a finding that the act or omission considered as negligent was the proximate cause of the injury caused, because the negligence must have a causal connection to the accident. So in this case, the respondents failed to show that the negligence of the petitioner was the proximate cause of the death of the victim. So the immediate cause of the accident was not the negligence of St. Mary's or the reckless driving of James, but the detachment of the steering wheel guide of the Jeep. Liability for the accident, whether caused by the negligence of the minor driver or mechanical detachment of the steering wheel, must be pinned on the minor's parents primarily. The negligence of petitioner was only a remote cause of the accident. Between the remote cause and the injury, there intervened the negligence of the minor's parents or the detachment of the steering wheel guide of the Jeep. Okay, so that is all for parental authority. Thank you for listening, and don't forget to subscribe to this channel.